Hello, I'm David Roger, General Counsel for Las Vegas Police Protective Association. In this video, I'd like to talk to you about searching property which might be abandoned. And so here is the scenario. An officer contacted me and said that officers found a cell phone which was apparently left by a suspect at the scene of a crime. And the question is that property abandoned? And if so, can officers search the phone to identify the owner, and i.e. the perpetrator of the crime? And so let's first talk about abandonment. When property is truly abandoned, the person who is the former owner of the property does not have standing to object to a search of the property. The person does not have a reasonable expectation of privacy. So, in a true abandonment case, the owner can no longer object to the search of the property. You know, we see this, sometimes when Intel goes and does garbage dump searches. They go by and they snatch up the suspects garbage in the middle of the night and they search through it. Maybe they're looking for DNA from maybe dental floss or a cup, or maybe they're looking for other information. That is a true abandonment case. But in the case of the cell phone, the Nevada Supreme Court, and quite frankly all of the courts, have said that it is a question of fact as to whether the person intended to abandon the property. And so the question becomes, when a suspect, flees the scene of crime and drops his or her purse or wallet, or in this case, a cell phone, did the person intend to abandon the property? From my perspective, in most cases, I think courts would conclude that the property was not abandoned. Conversely, a court could say that the property was in fact abandoned, but in most cases, courts would probably say that the person just merely forgot or accidentally left property behind. And in such cases, you would need a search warrant to go search the cell phone. And that is the case of State versus Taylor. The Nevada Supreme Court said it's a question of fact as to whether the person intended to abandon the property. But let's take a look at kind of a workaround. And I'm never in favor of trying to find workarounds when you have clearly defined laws, because if you're wrong and the workaround is found to be just a ruse to get around a constitutional issue, the courts are going to hold that against you, not give you qualified immunity. But in this particular case, I think that this workaround is reasonable. And in fact, there is a case that we'll talk about just briefly. And I, from my perspective, if you are simply picking up the phone, turning it on, and either the phone isn't password protected, or perhaps there's, like on many iPhones, there's an emergency contact function to the phone, and you're just looking for the name of the individual who owns the cell phone, I think that is a reasonable search. And in fact, in a Nevada appellate court decision, Flores versus State, the court ruled that way. And so first of all, the Flores versus State is a Nevada appellate court decision, which means it is not binding on the Nevada Supreme Court. But more importantly, it's an unpublished decision, which means it's not binding on courts, but it's certainly instructive. And in that case, Flores was involved in a bar fight, left his phone behind before the police arrived. Police found the phone. They accessed the phone. It wasn't password protected, and all they did was find his identification on the phone. They did not search the entire phone for any other evidence. They didn't look through the photographs or anything else. And they used his name and identification to do photo lineups later with the individuals, and they identified them. And at the time of trial, he moved to suppress his identification based upon the fact that he said that he didn't abandon his phone at the bar. And the Nevada Supreme Court said, well, in their opinion, in the Nevada Appellate Court, they said that from their perspective, he did abandon the phone. But probably more importantly is this. They said that the limited search of his phone for just his name, his identification, was not unreasonable. Stated differently, it was reasonable for officers to access his phone to get his identification, because that's what we do with lost property, is we try to find the owner. So it was not unreasonable, and his identification was not suppressed. I hope this helps you. If you have any questions, feel free to contact me at droger@lvppa.com. Thank you.
111, 110.